the judge spoke from an advantage position. He's the one presiding, and he knows what he may want to do. But as prosecutors, we cannot be certain that we will win our case. That one, we may go to court. It will go the other way. But perhaps the judge passed that on because he's sitting in a privileged position. So that's the response I'll give to that. But in any event,
Mr. Tuah-Yeboah, you cannot be certain that you will win your case. But at the Attorney Generals, as prosecutors, as we know from some prosecutors, unless they are sure of about, say, 80% success, they don't go to court. So you must have some conviction that you have a good case. That's why you go to court. Is that not?
Yes, we have a very good case. That's why we are in court. That's why we call 17 witnesses. But at the end of the day, it is the duty of the judge to either uphold whatever we presented or dismiss it. So far as we cannot deliver judgment in that matter, we cannot be certain someone wants to deliver judgment. We have done our part. Now, this business or this issue about making crime attractive or something, if someone is convicted for stealing, money laundering, you know the legal effects, you know the implications, you know the limitations placed on such people, because those offenses border on dishonesty. And if we take our constitution, there are clear provisions on how people have this kind of limitations because of their conviction on offenses involving dishonesty. If we move further, if you take the Companies Act, there are elaborate provisions on limitations placed on people who have been convicted for offenses involving dishonesty. You take the Act 930, the banks and financial specialized institutions, you have provisions there. So apart from the person going to prison, which is something that is also not ruled out, there are other serious limitations on people who are convicted.
Could you educate my audience a bit? What are these limitations you are talking about because of a conviction? And in which matter, what you are saying essentially is that using Section 35 of the Courts Act to settle the case doesn't mean that there will not be a conviction. There will be a conviction, and therefore, Mr. William Atu-Essien will still suffer the consequences of a conviction. What are these consequences that you are talking about?
Yes, Samson. First one, let's go to our Constitution. If you want to hold any public office, if you want to be an MP, if you want to be a minister, a deputy minister, if you have been convicted of an offense involving dishonesty, you are limited from holding such positions. Now, even if you want to be a chief, if you're a lawyer and you want to be a chief and be convicted for an offense bordering on dishonesty, you cannot.
In fact, you can't be a lawyer. If you're a lawyer, you lose your license.
That is it. If you're a business person like Atu-Essien, who is into finances, from the Banks and Specialized Deposit-Taking Institutions Act at 930, you cannot be a director of any financial institution or work in any position relating to finances of a company. You cannot. You are bad. If you go to a Companies Act, you cannot be a director. And so these limitations are there that if you think that you've been convicted, it's stealing, so you're going to sleep, you've paid, and that is it. I tell you, even if you are traveling out of state and you have a conviction of more law, a very serious offense, I tell you, there's a place that you go and nobody will even be ready to listen to you or even deal with you.
All right.
So there are serious limitations.
Right. We'll get to the